single day.
Obscenity Code lawsuit wraps up oral arguments. City Attorney, protecting children is the issue, not profanity. By Frank DeFury. Staff writer. Punta Gorda's attorney David Levin made his arguments on behalf of the city's obscene sign ordinance in court Thursday morning. According to Levin, the crux of the issue is not whether or not foul language can be used in public. If it were, our lives would all be a lot simpler, Levin said. Instead, the city attorney argued that the ordinance against obscene language is a narrowly tailored effort to prevent minors from being bombarded with unprotected speech in public spaces. Levin referred to the 2015 Supreme Court case of Reed v. Gilbert. The case involved a church suing a town for not allowing them to keep up an outdoor sign without a permit, despite non-religious signs having some exemptions to the permit system. Gilbert sent shockwaves around the country, Levin said, referring to how Punta Gorda itself adapted to the court's ruling. In that case, he said, the Supreme Court ruled that allowing certain kinds of speech and disallowing others was a content-based regulation that could not stand under the Constitution. By contrast, Levin pointed to the 1973 case of Miller v. California, where the prosecution of a man for mailing obscene materials as an advertisement was upheld. The Miller decision defines obscene speech as speech lacking serious literary, artistic, political, or scientific value, that appeals to the prurient interest of the average person according to community standards, and that describes sexual conduct or excretory functions in an offensive way. The city's ordinance, Levin argued, defines obscene language in a similar way and particularly bans signs or images defined as obscene in public spaces where persons under 17 can be expected to see them. Punta Gorda attorney David Levin's son file photo by Daniel Sudfin. The two plaintiffs in this case, Andrew Sheets and Richard Massey, were cited by Punta Gorda code enforcement for flying flags reading F. Biden in such public spaces in separate demonstrations. Levin noted in his argument that alternative methods of speech or redress are not prevented by this ordinance, they are still free, he said, to say indecent words out loud in public spaces or host signs away from where children are reasonably expected to be. He also argued that making the ordinance under the authority of the Code Enforcement Board, rather than a criminal offense, was to make it less onerous on possible violators, countering an argument previously made by opposing counsel. Their attorney, Fairs Heindel, had previously argued against the ordinance in his oral arguments on Monday. When Levin concluded his initial remarks Thursday morning, Heindel began his counterarguments, one of which being that no community standard had been articulated and thus no legitimate state interest could be met by the city's narrowly tailored method. The compelling interest has not been met here, Heindel argued. Judge Jeffrey Gentile thanked both attorneys for their time after their arguments on Thursday, saying that the lawsuits filed by the plaintiffs represent an interesting case. Gentile said that he would not make a ruling on Thursday, but would take time to review the materials cited by both sides before coming to a conclusion. Copyright Suncoast Media Group, Inc., edition August 5, 2022. Powered by TNAVIA. https://tinyurl.com/y6rk5hbk. Oral arguments begin in obscene sign city ordinance. By Frank DeFury, staff writer. Punta Gorda, a city ordinance against obscene signage represents a narrowing of free speech, according to the lawyer of two men suing over it. Attorneys for both the plaintiffs and the city appeared before Judge Jeffrey Gentile on Monday to present oral arguments in two lawsuits concerning an ordinance in the city code. The hearing was hosted on Zoom, with attorneys and interested parties calling in to observe the proceedings. Fairs Heindel, representing the plaintiffs, referred to the code ordinance as shifting the boundaries of First Amendment speech. This regulation is unbridled, not restrained whatsoever. This is just a wrecking ball to the First Amendment, Heindel said in the Zoom hearing. The ordinance in question, passed by the Punta Gorda City Council last year, prevents offensive language from being displayed in public places that can be viewed by children under 17 years of age, Such displays include clothes, flags and signage. The ordinance defines offensive language as including fighting words, indecent speech, or obscene words, as well as anything that would depict sexual or excretory activities or organs in a manner that is offensive as measured by contemporary community standards. The two plaintiffs Andrew Sheets and Richard Massey both filed separate lawsuits against the city of Punta Gorda after they received citations for violating the ordinance. Shortly after the ordinance was put into effect, both men flew flags which read F. Biden unredacted in a public space. Both men later retained the services of Heindel for their lawsuits. Heindel is an attorney from the Rutherford Institute, a Virginia-based nonprofit legal organization. Heindel, the first to go on oral arguments, spent most of his time referring to previous case law. One of the cases Heindel cited was a 2015 Supreme Court case Reed v. Gilbert, where the Supreme Court unanimously struck down a city ordinance that banned outdoor signs without a permit while allowing exceptions. The suit was brought by a church that put up its own sign, arguing that the ordinance erred in not affording religious messages the same exemption as political or ideological messages. At one point in his arguments, Heindel read directly from the case, "Content-based laws, those which target speech based on its communicative content, are presumably unconstitutional." Heindel also referenced FCC v. Pacifica, the infamous 1978 Supreme Court case involving material from comedian George Carlin, being referenced in a legal brief by City Attorney David Levin. The case confirmed that the Federal Communications Commission had the authority to regulate indecent speech on public airwaves. Heindel alleged that the city government was attempting to import the rules of the FCC for in-person, public space demonstrations and protests. "It tries to tell people what they can say and what they can't say, so this is a content-based regulation," Heindel argued. He went on to note that the principle of strict scrutiny would allow narrowly tailored control of speech for a compelling government interest. However, he argued that setting moral standards in terms of language use did not meet those standards, particularly because many community members may be more interested in free expression than propriety in language. Heindel also stated that making the signage ordinance a matter for code enforcement rather than a criminal offense may be a more onerous burden. He argued that since the Code Enforcement Board does not confer constitutional protections or require as much training from members as court judges, the ordinance put his clients at a disadvantage to initially challenge its legality. Oral arguments are expected to continue Thursday morning, with Levin making his arguments in favor of the ordinance and the city government's decision-making.